Ha! We're finally on. Oh, I know what the problem is. The university Wi-Fi is not working. I mean, come on. You rely on institutional Wi-Fi to get stuff done, and then you have to do stuff from a hotspot on your phone. Isn't that disappointing, ladies and gentlemen? So yes, this is very disappointing, I have to say. Give me like the thumbs up or something to acknowledge the effort it took to connect to this. This is so annoying. Yes. What can I say? I'm hugely disappointed. How are you guys doing today? This is the last stream of the series. Because we've been doing SQE1 MCQ streams for quite a while now. And this is the last one that we've got scheduled from this set. So I had set out to do 10 sessions. And I'm very pleased with myself that I managed to deliver all those sessions. And today we are in number 10. So if you guys want to see the previous ones, these are all listed, available to the public. So you can go have a look at the things that we've done previously, all the previous topics we've covered, the series of topics we've covered: contract, we've covered tort, we've covered business law, we've covered dispute resolution, we did some stuff about civil litigation as well, we've done criminal law, we've done all sorts of things that you're gonna find in the previously listed live streams. So that's great. I can see we've got some people connected live, which is fantastic. Thank you very much. So yes, so we are now having to deal with this through the phone because the Wi-Fi has let us down. This is, disappointing, but such is life. At least, look, if you look out the window, I'm currently in central London, close to Oxford Circus. And if you look out the window, is a very nice, bright, sunny day, which allows us to kind of open the windows and kind of turn up in a t-shirt, which is fantastic, better than what we usually manage. So what are we going to talk about today? We are going to deal with some things that have to do with the legal system. So I left the last two seminars that we had to do together, last week's live stream and this week's live stream. I've left it devoted to the legal profession, the court system, some aspects of litigation, and so on, to make sure that everybody is up to scratch with these ones. And as we're kind of tumbling our way towards the July exam, I know a lot of people are going to turn around and work on those. I've got a few specific pre-recorded videos that are linked down in the description that have to do with civil litigation, that have to do with courts. I've got now a couple of new ones that are available for our members that are on solicitor ethics and solicitor accounts. So these are interesting things to have a look at. Now, I said that these videos on solicitors, dispute resolution, the judicial system, and everything will eventually be available for free for everybody, but they're all currently scheduled. And what happens is that if you are a member of the channel and you can support me by buying me a coffee on a monthly basis, such as this inappropriate messaging, YouTube is going to kick this off. So that's the cup of coffee. So if you want to buy me one of those, $2.99 a month, you become a channel member, and you can see the totality of the videos, all of them front-loaded, so you can log in and watch everything straight away. And what else I'm going to do? I am now listing some shorts that are members only. So this is some of my more edgy stuff that, I'm not particularly comfortable in making this available to the whole population. So I'm unleashing those on our members only. So you're going to see on the members only feed on occasion some additional shorts that are coming up. These are just for you guys. Right. So, we got a question from Maria. Well, I will do more live sessions. And the logic here is that I wanted to do this set of 10. So we cover key topics useful for people's SQE preparation looking up towards July. And now we're completing this set. But it doesn't mean that I'm not going to do any more live streams. I'm going to do the, perhaps not on a scheduled weekly basis, but I'm going to do the occasional student hangout. If you go through the list of live streams, there are already like a couple of handouts that I've done. They're a bit more informal. They've got different themes. They can be about, preparing. They can be about well-being. They can be about kind of approaching study or career aspirations, all those sorts of things. You can let me know in the community forum what you guys are most interested in, and then I can schedule some student hangouts that can help us with those. So we're going to do a few of those as we're working our way towards the July exam. Then we're going to take a little bit of a break over the summer, or maybe not. I mean, I don't know. It depends. If I can run this current stream off the Wi-Fi on the phone, because the institution is not working, then I can probably run this from a beach somewhere in Greece. So we're going to be good. We can do more student live streams over the summer. And then when we get into September, for the people that are starting from, say, late August or beginning September, their preparation, looking forward to the January 2026 exam, SQE1, I'm going to do another set of 10 topic-specific SQE1 prep classes. And these are going to come on the back of the new study planner. I'm designing now a new study planner that is going to launch for you guys at the end of August. That is breaking down the FLK looking towards the January 26 exam. Those of you currently working towards the July exam probably already have seen the study planner I had. There's a link down in the description for that as well. So that's the idea. The idea is that we hang around together both to support the community and to support each other, and we're doing substantive classes on specific topics to help us with our preparation. And this is a way for me to kind of tell you guys about the other tools that we've got available, like the study planner, particular videos on particular areas, and so on. Now, at any time at all, either through the chat in these live streams or through the comments in any of the videos, because I see all of those. If you've got any suggestions on what you would like to do, what you're missing, if there are topics that you're missing out on, or if the areas that you find more difficult that you would like to talk about, then we can organize either additional videos that I can prepare, or we can do additional streams. Right? Okay, guys? Good stuff. Right. Give me a thumbs up if you're enjoying the show. And if you're comfortable doing that, tell me in the chat where you guys are connecting from. So as I said, I'm in central London at the moment, in the sunshine. It never happens. I really should have picked a different mug. Oh yeah, right. Now let's start with our normal sequence. So I'm going to share my slides, and then we can go through some MCQs together. Let's see. Ooh, Maria's in East London. Cool stuff. We're not that far away. Okay, we could can I get a coffee or something, I mean, I know that we tend to forget that this is possible, but we can actually meet in the real world. I met Anne, who's this lovely guy that has law drills that, I tell you guys about, the AI tutor and kind of mock tests and so on. And we keep meeting on Zoom calls. And I was like, why don't you come over? Like, we'll have a coffee. So we had like a coffee. I could have picked a better coffee place, to be honest, but we did have like a nice coffee down here. And it is refreshing to see people in real life as well, especially if you're preparing for the SQE on your own and you're feeling kind of stranded somewhere. It might be good to get together. Okay, so let's get going with some questions. So the topic today is the legal profession. We have also judges, the preparation of courts, and all of that stuff. So this is the thing that we're going to be focusing on today. Right. Scenario number one. Emily has recently graduated with a law degree in England and is considering becoming a qualified solicitor. She learns about the new qualification process introduced by our friends at the SRA, known as the SQE. However, she is uncertain how this route differs from previous pathways, particularly concerning training requirements and assessments. Question for you guys. Which of the following correctly describes a key difference between the traditional route to becoming a solicitor, the LPC, and the new solicitor's qualification examination, the SQE? Is it A, Under the SQE route, candidates must complete 2 years of qualifying work experience, but unlike the LPC, this experience can be obtained from up to 4 different employers or placements. Is it B? Under the SQE route, candidates must always undertake a formal training contract with a single law firm for 2 years, identical to the traditional LPC. Is it C? The SQE consists entirely of coursework and practical assignments, whereas the LPC required candidates to pass formal examinations. Is it D? The SQE route removes the requirement for candidates to hold an undergraduate degree before qualifying, unlike the traditional LPC route, which required all candidates to have a law degree. Or is it E? The LPC route required no practical work experience at all, whereas the LPC introduces a mandatory 2-year formal apprenticeship, right? Okay, is it A? Is it B? Is it C? Is it D? Let's play around with some props. What do you guys think about this? Okay, so vote now or forever hold your peace. I'm hiding the offensive cup. Then we're not going to be able to have advertising on the video if we've got like nasty stuff showing it. But then no, in case YouTube is listening to us, there's nothing wrong with this mag. Okay, Maria says A. Does everybody agree with this? Yes. Oh, we got tunes as well. Hey, how are you doing, man? I saw your comments on the other videos when you were posting the what you thought were the correct responses. Thank you for doing that. It's awesome to see that people are kind of thinking about the questions even if they were not here to catch us live. That's amazing. Okay, so everybody votes for A. Yes, you guys are correct. Under the SQE route, candidates must complete 2 years qualifying work experience. But unlike the LPC, this experience can be brought together from different providers. So you can have up to 4 different providers. I have a couple of videos. I think I've got a live stream as well discussing the QWE, what counts as qualifying work experience. I think this is worth getting into a little bit. Yeah. Now, you guys are probably, if you're younger in this, then you're probably not super familiar with what was happening in the past. In the past, you needed to do a law degree, which was recognized as a qualifying law degree. So you needed to do a law degree that conformed to the specifications of the regulator. Before it was somebody else, now it's the SRA. Now, this doesn't really mean a great deal of stuff. It just basically meant that you needed to be taught in your law degree the basics of what you now consider to be FLK1 and FLK2. Well, perhaps not without, I need to say this, without all the procedural bits, because the FLK now contains a great deal of procedural things like the civil and criminal procedure. This was never part of the normal law degree. So you needed, however, to do what they call the qualifying law degree. So you would do that, and then you would sign on for the LPC, the legal practice course, which is, and actually I've got a video now I remembered on comparing the LPC to the SQE. What was happening with the LPC is that you were effectively doing something like a master's degree, but it didn't lead to an academic qualification. It was a vocational qualification. Having said that, it did cost you a bundle of money. So it pretty much cost the same as you would do a master's in law or an LLM. That's why many students chose to do an LPC/LLM, meaning they would go through the FLK and then they would do a dissertation in the end, which gave them the academic credit. So they would pay once, like perhaps a couple of thousand more, and then they would get an academic qualification as well as the vocational, which, was better value for money. What happened after the LPC? Horror is what happened after the LPC. Because in order to qualify, you needed to get yourselves a training contract. The training contract was the structured period of training within a law firm that you needed to do for 2 years. Now, why is this so terrible? You must have read in the press that they pay a bundle of money to trainees. I know, they do. It's shocking. They pay trainees more than they pay me to do all this stuff. That's why I have to do YouTube. But anyway, so their trainees are normally well compensated in the bigger law firms. They're adequately compensated in the smaller high street and regional law firms. So that's fine. So what's the problem? The problem is there aren't any spaces. So the law schools were churning out people with law degrees. The LPC providers would take on a great deal of people, and they were churning out people with LPCs. And then there would be this enormous bottleneck that people couldn't find the training contract, so then they could never get the parts that they needed to complete the qualification and become solicitors. Now, this was one of the reasons that the SRA gave for changing the old system and introducing the SQE. I'm not a fan. You know this, right? Anybody who's been following me for a while knows that I'm not a great fan of the SQE, and I've been telling the SRA every opportunity I have. But there's one thing that they've done that has been positive, which is to deal with this bottleneck. Now they recognize as qualifying work experience work in the broader legal domain. So you don't specifically need to be in a law firm. You just need to have a supervising solicitor, and you don't need to go through the formal steps that you needed to do when you were doing the training contract. So it is easier to find somewhere to do the qualifying work experience, or to recognize your existing work as qualifying work experience when you're trying to qualify for the SQE. So that is a positive development. Now, everything else is up for debate. So the correct answer here is that, as we said, under the SQE route, you need the qualifying work experience, and you can have it from multiple providers, as opposed to what was happening under the LPC. Additionally, because this addresses one of the questions, one of the options we've got there, you no longer need a law degree for the SQE, but you need a degree at graduate level. So you need to have done a degree from something that here or overseas. It doesn't have to be law anymore, but you do need coming straight from school. So that's it. Am I getting disconnected now? So hopefully I'm still on. Let me see. Yeah. If you lost me, tell me in the chat, because the to be playing up. Man, we're not having much luck today, are we? You will have found, and I think this is worth mentioning, that many of the providers of the LPC have now revamped their LPC into an SQE prep course, and some of them continue to bundle the Masters in Law, which is the LLM. So if you guys are after more traditional campus-based, tuition-based experience for your preparation, you can still do one of those programs like the SQE LLM packages, and then with the preparation for the SQE, and in addition, an academic qualification. So this is something to think about. It is something to think about as you're thinking about your preparation. Now, packages, I'll tell you what, if you're willing to pay for a kind of campus-based, tuition-based prep school, you might as well get an academic qualification at the end of it. So, it doesn't seem like a bad idea. And many of the big providers like City University, the BPP, the College of Law, that's now called the University of Law, they're offering these packages. So I would do some shopping around. I've reviewed, if you guys need support in selecting a prep school, I review almost all the online distance providers, and I put comments about them in my community forum on this channel. So I would advise you to go have a look at those posts. And I did have a student of mine in here the other day to select a prep school, and the one that she had selected is not one that I would recommend. And I did tell her, look, to get at least an initial idea of which ones are okay and which ones are not, go to look at those reviews that I'm doing on my posts. If I don't have a relationship with any of them. If I do have, and I'm explicit about this, so you get, don't do what this girl was doing. Nice, and she's very clever, and she's done exceptionally well. But she looked at the reviews online, and she thought it would be okay. So she saw the kind of self-proclaimed reviews, and she assumed that this would work. So do not look at self-declared anonymous reviews that the prep schools are putting for themselves, right? Don't do this. They're probably fake. And if you're looking for value for money, maybe, as with everything else in life, somebody who looks cheaper than everybody else is probably not that good. Okay, right. Now let's continue. So long as the internet connection is holding up, let's try and go through the next question. Hopefully this is still working for you guys. I see we've got like a lot of people connected today. It's just my luck, isn't it? On the days that this thing's not working, I get a lot of people. On the days that the internet is fantastic and everything works well, I'm there talking to myself. What can you do? All right. Now, question number 2. Are we okay? Give me an enthusiastic emoji if you guys are still okay and everybody's still connected and everything's coming through. So I know that we're all working. Let's go. If you want to see more props, give me an emoji of your choice and I will display more props during the session. All right. Question scenario number 2. Daniel is involved in a contractual dispute with Buildfast Limited. This is a construction company that has performed defective renovation works in his commercial property. The claim is for £20,000, and the court has directed the parties to provide disclosure of documents within specified time limits. The deadline for disclosure by 2 weeks due to administrative representing Buildfast applied to have Daniel's case struck out on the grounds of failure to comply with procedural deadlines. Daniel's solicitor now seeks relief from sanctions. These are the penalties that you get from the court for being late, arguing that the delay was minor, unintentional, and caused no significance to the case of Buildfast. That's what they have to say for themselves. Now, question for you guys. When considering whether to grant Daniel relief from sanctions, which aspect of the overriding objective under the civil procedure rules will the court focus on most closely? Is it A, ensuring both parties have equal financial resources to pursue the litigation effectively? Is it B, ensuring strict adherence to all procedural rules regardless of consequences to the parties involved? Is it C, dealing with cases justly and at proportional cost, balancing fairness, efficiency, and the seriousness of non-compliance? Is it D, prioritizing speed above all else to maintain court efficiency, thereby strictly enforcing deadlines regardless of circumstances? Or is it E, allowing complete discretion for judges to disregard justice requires it, irrespective of the rule? Okay, what do we think? Is it A? Is it B? Is it C? Or is it D? We have the votes in. This is beginning to feel like the Eurovision. Are you guys into Eurovision? It's on in May, isn't it? Yeah. I'm a big fan of the Eurovision. Yeah, we make a party out of it and so on. Maybe we can have, would a SQE themed Eurovision party work? Probably not. Yeah, we probably don't want to mix those two. Okay, the correct answer, you are right. The correct answer is C. Dealing with the cases justly and at proportional cost, balancing fairness, efficiency, and the seriousness of non-compliance. This is what the court is going to try to do. Now, what is the overriding objective? The overriding objective is the background logic for the entire operation of the civil procedure rules. This is, and in fact, yes, it does. Every time we're in the field of dispute resolution, as Maria is saying in the chat, we need to consider, if we're in a civil dispute, the civil procedure rules and what feeds and motivates and informs everybody's behavior under the CPR, and the interpretation of the CPR is the overriding objective, which is about what? It's about doing things efficiently in terms of money and in terms of time, but also doing things fairly in order to achieve just outcomes. And the courts here do have a degree of discretion as to how they understand and apply those rules. So the reason why the correct answer here is C, is because in the interpretation and application of the overriding objective, the judge will have a certain degree of discretion as to what they do in trying to incentivize the parties to keep to deadlines and respect the rules. Now, to be honest with you, I don't think they should waive the sanction here, because the solicitors not being effectively organized and doing their job and being delayed for 2 weeks is actually a big deal. Yeah, even if it didn't have a negative consequence on the other party and in putting their case, it does have consequence on the organization of the court and the way that the court allocates its time. So I think they should face the sanction. The sanction is going to be paid by the solicitors. It's not going to be passed on to the client. So if it's the solicitor who's at fault, then they should suffer the consequences for it. Now, this is not simply about financial resources. So it's not only about the costs that the delay is causing. So A is not the right answer. We don't have strict adherence to the rules without any context, because then we would not be meeting the objective. And having said that the judges have a degree of discretion doesn't mean they can disregard the rules every time. So we need to understand that there are rules and that these rules are respected by the court, but there is some degree of yardstick for interpreting that discretion is. Now, one thing that I want to say, that when we're going through these areas of the FLK, I would advise caution, because the majority of us are having a problem with the procedural stuff. If you're fresh out of law school, then you will have done a lot of stuff on substantive law. You are very unlikely to have done anything that is procedurally focused, because as part of the traditional law degree, we left this for the LPC while the LPC was still existing. When the LPC went out the window, we still didn't amend our programs to teach civil and procedural rules, for the main reason that most of the people who teach at law school, like myself, are academics, we're not practitioners. So we really don't know much about teaching this, as opposed to teaching people the particular technical tools that they need in order to carry out the profession. Now, clearly the SQE is changing all of this. So we need to be now more minded of how people are going to meet the kind of day one criteria so they can become solicitors. So now the schools across the country are revamping their procedure, their final year modules, and of criminal and civil procedure. So you're more likely, if you're studying law, if you started, say, in 23 or 24, you're more likely to have heard of the overriding objective. If you were studying law prior to those dates, they would never say anything about procedure. I mean, I've done like a stack of law degrees. Nobody ever said anything. SQE. All right. Cool. So are we all happy here with the way the overriding objective is meant to work? Have a look at I've got a long lecture on the civil procedure rules and dispute resolution that takes you through the totality of the system and how it works. High level, of course, not every single detail. But then again, what is requested for you for the FLK for SQE1 is like a high level understanding of how these things work. All right, cool. So let's move on. Oh, going the wrong way. 3. If I managed to scroll the 3, ladies and gentlemen. What is happening in scenario 3? And let's check that the internet is still, miraculously, it is still on. Maybe I shouldn't be touching it, right? That nothing ever comes from touching the stuff. Isabella is studying law and is trying to understand the differences between notes that different courts handle different kinds of cases, but she's unsure exactly how they differ in terms of their functions, jurisdiction, and the types of matters they address. She is reviewing the roles of the magistrates court, the county court, and the high court. Question for you guys. Which of the following statements correctly identifies the main differences between the magistrates court, county court, and high court in England and Wales? Is it A? The magistrates court primarily deals with minor criminal matters. The county court handles most civil disputes involving moderate amounts, and the high court hears complex or high value claims. Is it B? The county court exclusively handles all criminal cases, while the high court deals exclusively with civil disputes and the magistrate court handles appeals only. Is it C? The high court handles only family law. The county court deals exclusively with criminal, and the magistrate's court oversees administrative appeals. Is it D? The county court and magistrate's court share identical jurisdictions, handling both criminal and civil, while the high court only hears appeals. Or is it E? The magistrate's court has authority over serious criminal offenses, the high court handles only appeals, and the county court has jurisdiction exclusively over claims going beyond £100,000. Okay, what do we think? Is it A? Is it B? Is it C? Or is it D? Okay, Tune says A. Do we have any other votes? Of people coming in and out. I think what happens is that when playing ads on people, then it shows them as disconnected and then they come back in. That's my theory anyway. Or it could be that everybody's having the same internet connection problems that I'm having today. Hopefully not the latter. Okay, so we've got one vote for A. Are you ready? You ready for the result? Yes, in fact, the correct answer is A. The magistrate's court usually will deal with minor criminal matters. The county court will handle most civil disputes with moderate amounts, and the high court hears complex or high-value claims. Now, what we need to distinguish is that we don't want to mix up the different courts and how the different courts sit in the structure of the judicial system. We don't want to confuse that with the track allocation system. Because the track allocation system, as we've seen in the other classes that we had on dispute resolution, has to do with giving different pathways with different predetermined steps to different types of disputes, primarily according to their value. This is mostly used within the county courts when there are similar things for criminal for the crown courts, but it's usually used in the middle level of the court system in order to effectively allocate different types of disputes within that system. So on the one hand, we've got different courts that are handling different things. And even within the same courts, we have the track allocation system, which might give us different pathways so the disputes are handled more efficiently. Now, why do we have all this? That evolved in order to meet basically the needs of the user, right? The users, the solicitors, the barristers, and the litigants. And we've had these reforms that streamlined this situation that came into effect in the early 2000s. Before we had all this, there was a great deal of confusion as to what would be the best way to progress a case. And yeah, I tried to switch to, I think definitely the dead. I tried to switch back to the university Wi-Fi and then poof, nothing happened. That's right. Okay, so hopefully you guys can see me. Yes, we're back on. Man, like I cannot believe how annoying this is. I mean, I've done streams up in the mountain and I had less internet issues. Okay, so what I was saying is, in case you missed it, that the changes in the way that the civil procedure system works were to offer pathways that can efficiently deal with the resolution of disputes. And these pathways work both between different courts that are tasked with different things and through the track allocation process to different pathways within the specific courts. So that's the idea. And this is why the correct answer here is option A, that has minor criminal issues going to the magistrate's court, and then moderate civil disputes going to the county court, and then the more important things going to the high court. Anybody done jury duty? Have you been called to do jury duty? Yes, and it's really fun. It's a fun idea, the jury duty. I juror at Kingston Crown Court, which is horrible. I mean, all of the Crown Courts are horrible because this is complex criminal matters. And while I was there, they said, look, we got a couple of kind of massive fraud cases coming on, which are likely to drag on for months. Months. Okay. And they said, if anybody has a problem with it, can you let the judge know just in case we can excuse you? And I went there and I was like, please no, we have just started classes. I cannot be gone for the entire term. I'm gonna miss the classes for an entire term. I've got a baby at home. I cannot be down here at bloody Kingston every day. And I was lucky. They excused me. So even though I went for jury selection, I came back out, and then I was waiting forever. People were sent kind of to various rooms and so on, and I was still waiting out there. And in the end, they said, "Oh yeah, you the lecturer guy, you can go home. You don't have to come back tomorrow." And I was like, "Yes!" But yeah, jury duty happens to everybody. So if you're permanently you don't even need to be a citizen here. If you're permanently resident in the UK, then you can be called for jury duty. Yeah, and when that happens, you're in trouble. Oh yeah, Tunes is asking how do you subscribe. So you need to click the join button. So that's the only thing to do. But probably I don't know whether you can see that while you're currently on the live stream. Actually, probably under the video, there's an option to subscribe to the channel as you have done already. But there's also something that says join. If you click the thing that says join, then it asks you to pay $2.99 to YouTube. YouTube keeps a lot of that money, but then gives me enough to get myself an espresso. And then you can become a joint member of the channel. And as we said, what happens with that is that you can see all the videos that I've got scheduled straight away. You don't have to wait for them. You can see special videos like special shorts that I'm making available just for the community. And you have access to the members only Facebook group, where there's a kind of more tight community of scholars where we talk about the SQE and stuff that is only for paid members. If you need any information on this is going to be given to you through the joining process. Just one thing about Facebook. If you've got a different name on Facebook, then do email me or something and tell me what the name is, because sometimes I got people who are not members of the channel trying to join the members only Facebook group. And if I cannot match the names, I don't know who is who. Right? Cool. Let's move on to our final question for the day. There we go. Man, everything's so fiddly. Question 4. Now, Maya is a solicitor. She's working with a medium-sized law firm. She has recently been approached by existing clients who are also business partners, Olivia and Rachel. The business partners have developed disagreements regarding the future direction of the jointly owned company, and each partner wants Maya to represent their individual interests separately. Maya has acted for the company in the past, advising on general business matters. Maya is concerned that acting for both Olivia and Rachel individually would pose ethical difficulties due to conflicting interests. Question for you. Under the SRA's Code of Conduct, what is Maya's best course of action in relation to the potential conflict of interest in representing both Olivia and Rachel? A. Maya can represent both Olivia and Rachel individually, provided she obtains their consent, even if there's a significant risk of conflict. B. Maya can decline to act for both Olivia and Rachel individually if there is a significant risk that their interests conflict, unless she can take sufficient steps to mitigate that risk. C. Maya can proceed to represent both clients individually without concern, as long as she charges both clients equally to avoid any financial bias. Is it D? Maya is required to withdraw from acting for both Olivia and Rachel, as the SRA strictly prohibits solicitors from advising separate clients with any historical business relationship? Or is it E? Maya must represent the client who approached her first, as per SRA guidelines. Conflicts of interest are resolved on a first-come, first-served basis. Okay. Right. What do we think? I like the first come first serve as an option. Oh, Maria is asking whether I'm going to do a WhatsApp group. Guys, no, I cannot, because WhatsApp groups are the bane of my life. I mean, don't tell anybody. I hope that the people from the school, my kids' school, are not watching this, but they've made so many WhatsApp groups for the kids' school. The phone's like kind of buzzing nonstop. I just cannot cope with WhatsApp groups. That's why I thought we have the Facebook group and we can communicate in this one. Now, if there is immense public demand, we could do a Discord group perhaps, but I just cannot cope with WhatsApp groups anymore. Sorry. All right. So what do we think about Maya? Do you think she can represent these people and avoid the conflict of interest, or she shouldn't? Okay. Now, Tune says B. Do we all agree with this? I am, even though I like the idea of first come, first served, I think we're going to have to agree with this. Yeah. B is the right answer. Maya must decline to act for both Olivia and Rachel individually if there is significant risk that their interests conflict, unless she can take sufficient steps to mitigate. But I think this is going to be difficult. So the ethics part is a significant component of the FLK, and it appears both is examinable both within FLK1 and FLK2. So you need to be familiar with the SRA's code of conduct, which contains the key ethics requirements. Managing conflicts of interest is a significant component of doing this. The solicitors have a duty to act in the best interests of their client. So if this conflicts with another client, then we have a problem because they're going to be in breach of one of those obligations, right? The obligations to one of those clients. And also, how are you going to deal with confidential information? We're not talking about a firm of solicitors that instructs different solicitors within the firm to deal with different people, right? Here, Maya is called upon to represent both people herself. So it's going to be impossible to create adequate firewalls, or actually they're called Chinese walls, the sort of artificial distinctions, so information doesn't go from one client to the other. She's going to have great difficulty separating the interests. She's going to have difficulty dealing with confidential information. So I really think she should not. Solicitors must not act if there's significant risk of conflict. And I don't think she can take enough mitigating steps here to deal with this. What are these mitigating steps? They are steps to take to ensure independence and confidentiality. And again, this cannot be done if the solicitor is acting for two parties that might be at cross purposes. I mean, I'm not talking about, a conveyancing solicitor acting on behalf of two people who are purchasing a house together, okay? I mean, obviously they have the same objective. It's not a problem. But you couldn't have the same solicitor acting as the seller's solicitor and as the buyer's solicitor, because then there's an obvious conflict of interest that cannot be effectively resolved, even for things of a technical nature like conveyancing. If you're interested in that stuff, I've got a couple of videos that I struggle to make on conveyancing and property law. So to honor my trouble in putting those together, you can watch them. Okay. Right. So how are we feeling about all this, guys? This was the last question that I had for today. So have we found this useful despite the multiple and continuous internet problems? So if you've enjoyed this and you managed to stick it till the end, and you're watching this on the replay and you're not already disgusted by the constant interruptions, give us a thumbs up or put a comment under the video when you watch it later to let me know how you're feeling. Now, considering this is the last stream for this set. As we said, we were doing a set of 10 live streams covering essential bits of the FLK. How are we feeling about things generally? Are we the not so sure gnome, or are we the happy gnome? So if we needed to represent our preparation for the SQE in the form of gnomes, Would we pick the I'm scared gnome that doesn't look too happy, or would we pick the happy gnome who's, holding a carrot for some reason? Yes. Which gnome are we? I'm not sure we can actually have happy gnome for anybody that's preparing for the SQE, because it is not a fun process. Not at all. So yeah, so let me know, guys, either in the comments of this video or in the community forum, what you feel like doing for our next live streams, whether we should pick a specific topic that has to do with the FLK and investigate this in a little bit more detail, or whether we should simply do a hangout where we have a kind of looser agenda and we sit around and talk to each other. So let me know what would work best for you, and then we can get that done. I try to do these live streams normally on Wednesday lunchtime. The reason for this is that I think lunchtime is good because people might be having a break from work, but it also kind of fits on my schedule in between my other classes. But if you have a preference for another time, I don't want to do weekends because I need to stop working at some point. But if you have a preference for another time in the week or another day that would suit you more, so let me know, because I'm not wedded to Wednesday at 12. I could do another time. Okay, cool. So guys, fantastic. Thank you so much. Thank you so much for joining. Thank you so much for being so active in the chat. It's lovely to see we have some channel members there as well. So I hope it's been a good experience. Apologies for all the internet interruptions, and I'll see you guys in our next hangout. Thank you, and see you next time.